Thank you all for coming today. My name is Michael Swerdlow, and I am a member of the Law and Political Economy Society here at Columbia Law School. On behalf of our organization, as well as our co-sponsors, RightsLink, the National Lawyers Guild, and the Environmental Law Society, I am here to introduce our speaker today. The crimes of Chevron and the Amazon, how firms like Gibson Dunn make Chevron's business model possible, and the ordeal of Mr. Donziger may be the most instructive case for law students to understand how power works in the American legal system. This case exposes how corporations, the firms that represent them, and American judges can use their power to structure the economies, the public health systems, and the climate crisis in countries across the globe, such that profits are privatized by large corporations and harms are forced upon the public, particularly vulnerable communities across the global south. His case shows us that being an attorney in the United States means that one day you may be asked to decide whether to protect the lives of your clients or to submit to incarceration. Alternatively, for graduates of Columbia Law School, it may mean being asked to prosecute someone like Mr. Donziger on behalf of corporate clients, or to work to deny communities that have been devastated by corporate clients their justice. Mr. Donziger is here today to help us meditate on the question of what it means to be a servant of the court in a legal system like this one. Without further ado, we are excited to present Mr. Steven Donziger.
Thank you for that nice introduction, and thanks to everyone for having me today. It's an honor to be invited to share a little bit of this very long story that really began way back in 1993. I think what I'm going to do is talk for maybe 15, 20 minutes and then open it up for questions, because there's so many interesting angles to this, particularly from the perspective of law students. There's career issues, there's ethics issues, there's basic justice issues, there's court corruption issues. There's so many aspects to this, so I like to open it up quickly. So I'll talk a little bit, give a brief overview, and then we can sort of have a conversation. I want to just mention that I have had the opportunity to speak to a bunch of law schools. I got out of detention a year ago this month after 993 days, mostly at home, but also 45 days in prison. And during the time I was on detention, I decided to speak to anyone who invited me, including kindergarten classes. I was like, I am going to tell this story as far and wide as I could. And I started to get invitations to all sorts of law schools, some well-known, some not as well-known, all over the country. And I never got an invitation to come here, even though it's like my neighborhood law school. So this means a lot to me to be able to walk up the street and see all you beautiful faces here who are interested in these issues and this issue of justice. So thank you for having me. I think the way to sort of think structurally about this case, which by the way has lasted 28 years and is ongoing, is really to think about it in three buckets of sort of time. The first bucket was when it started in 1993. You saw some pictures of me as a young man. Am I up there? Do we need that, or can we turn it off? Or maybe we need it. Anyway, I first went down to Ecuador. I was 2 years out of law school. At the time, I was a public defender working in Washington, D.C., representing children accused of crimes. And I went on my own time with some people. We had heard about this pollution, and we decided to investigate. A group of lawyers and public health specialists, and it was a trip that obviously changed my life. And we decided to file a lawsuit in New York. At the time, Texaco, which was the company that had done this, was headquartered in White Plains, New York. So we filed here on the theory that in Ecuador, the indigenous communities, the farmer communities, could not get a fair trial in their own courts. They felt that, and understand that all of this damage that had been going on systematically from like the late 1960s to the early 1990s never once resulted in a judgment in tort against the company, even though the company was openly admitting that it was systematically dumping these cancer-causing substances into the environment, into rivers and streams that people in the region were relying on for their drinking water, their fishing, and their bathing, and people were clearly hurting and dying from these exposures to toxins. Texaco, which was the initial defendant, immediately hired a big corporate law firm, King and Spalding. Some of you might know King and Spalding, and they defended Texaco for the first roughly 10 years of the case when we were trying to get a trial here in New York City, and they argued that the case would be better suited to be litigated in Ecuador. Is there a way we could turn that off?
You want to turn off?
Yeah, I do, because like people are looking up there, I want them to look at me. Anyway, I'll keep going in the meantime. They fought to have the case in Ecuador, which is ironic, right? Because the Ecuadorian plaintiffs wanted to have the case in the United States, wanted to get a jury trial, felt like they could not get a fair shake in Ecuador. And if you can believe it, this battle over getting into the courthouse, this battle over jurisdiction lasted 10 years. Now think about that, 10 years. And by the way, these large oil companies, and I think this is true for a lot of large corporations, like delays benefit them because it's much cheaper to just delay and pay big law firms to not deal with the underlying problem than it is to actually deal with the communities you're hurting. So we had to go to the Second Circuit twice. Ultimately, they won that battle, and we went down to Ecuador. And I think their thinking at the time is that we would just disappear at that point. Like the model of most American plaintiffs firms is not to sort of chase a case into, another country, particularly in the global South, where you have to figure out the legal system, where the legal system is, you don't really know what's going on. There's cultural differences, other types of differences. You got to get local lawyers. It's complicated, and I think they sort of banked on us going away at that point. So we decided to keep going. We joined forces with some incredible young lawyers in Ecuador. I became much more involved at that point in the case personally, because I had studied Spanish in college, and I had been a journalist in Nicaragua prior to becoming a lawyer, and I just wanted to work on it. And I quickly realized that unless someone sort of really worked in it full time, it wasn't going to go anywhere, because they literally had like dozens of lawyers they had hired in Ecuador. They were trying to sort of sabotage and delay the trial. So the second stage of the case was in Ecuador, and it lasted from roughly 2002 to 2013. Okay? And then when I went down there, I started to travel there about every month. I've been to Ecuador, by the way. I live down the street. I've been to Ecuador 250 times or more. It's crazy, over 20 years. And I thought when we started it would take like 2 or 3 years maybe to do the case. It ended up taking 8 years just to do the trial, because their whole strategy, again, was it was cheaper to pay lawyers to sort of obstruct and delay the trial than to actually let the trial conclude, because the evidence against them was overwhelming. So ultimately, we were able to prevail, and I'll talk a little bit about how hard that was and the strategies that we had to use. But once we won, they vowed never to pay, and then they decided to target me as opposed to paying the people that they poisoned in Ecuador. And that has led to, I think, one of the most bizarre kind of developments, I think, in the history of the jurisprudence of this entire country. And before I sort of explain the details, I want to acknowledge that what happened to me, as difficult as it was, is far less egregious than what's happened to lots of other peoples in our nation's history through our court system, mostly indigenous peoples, land theft, massacres, murders, what have it. And obviously there's significant problems with issues of racial justice in this country that often play out through police killings and that kind of thing. So I want to just sort of say that to acknowledge that, I'm standing here today able to tell this story. And, but I think what happened to me I'd never seen before, and I'm really worried that it's going to happen again. And I think that as I describe this story, I really want to, and I hope one thing we can get out of today is that everyone can become more aware of this phenomenon of private corporate prosecutions and corporate influence and control over aspects of our judiciary that I don't think existed to this extent in prior years. And essentially, Chevron started by suing me personally under the civil RICO statute in 2011. Okay, remember, we won our judgment in 2011, the same year they sued me. And civil RICO entitles a prevailing plaintiff to collect treble damages. And at the time, our judgment was $19 billion, and they were essentially going after me for $60 billion personally. So I quickly realized that I was being sued for the most amount of money that any person in this country had ever been sued for. Okay? And I'm a human rights lawyer, and I spent most of my time working out of my apartment, again, down here on 104th Street. So I'm like, this is crazy. So, you know, at that point, as in most SLAPP lawsuits, that is lawsuits designed to harass as opposed to litigate on the merits, I had to sort of shift gears, and instead of focusing on enforcing the judgment against them, the judgment they wouldn't pay, I had to then figure out how to get my own legal team to defend me personally. And that really was the ultimate purpose of their attacks on me, was to basically take me out of play as a lawyer for the people of Ecuador and put me in play as the target of a separate lawsuit that it would consume my life, probably consume all my money, consume all my bandwidth in my head, and ultimately probably drive me crazy. Because I'm telling you, if I told any of you, and you're going to go out, and I'm sure most of you are going to do really good things in the law, but if I were to say, hey man, if you do this, you're going to get sued for like billions of dollars, okay? Can you imagine how you would feel? And like the purpose, and I want to break this down today, because the purpose really is to, in terms of their strategy, I think, is to use me to scare people like you. Like they want you to look at me and say, holy shit, like I don't know if I can really do that work, because these types of things can happen, which is why I think it's so important that I be protected and that we all understand this phenomenon. In any event, I went through this civil RICO trial. Chevron used at least 114 lawyers against me from Gibson Dunn. And I know that because in the course of discovery, they had to submit a privilege log, and we just counted up all the lawyers that they were claiming privileges over their documents. And I had a small team of lawyers headed by a man named John Kecker. He's a great trial lawyer based in San Francisco. Luckily, I had donors who were paying at least some of John's fees. But there came a point in time, like 6 months before the beginning of the trial, where John said, I think you should represent yourself. If I'm going to drop out, you should just go pro se, because I'm only making things worse for you. And I'm like, what do you mean? And because he's a great lawyer, but like the judge had denied me a jury. I was the first civil RICO defendant, and still the only one in the history of this country who did not get a jury trial. And it was all being orchestrated for a preordained result, because it was very clear my judge took an extreme dislike to me for various reasons that we could get into, some related to law, some related to psychology and his personality. But it was very clear he was engineering this trial to destroy me. Like I was not getting a fair trial. And my lawyer basically said, let me get out, you represent yourself, because they're just going to use my presence representing you as a reason to uphold the legitimacy of this very illegitimate process. So just go toe-to-toe with the judge. And literally for several months, I was going pro se against over 100 lawyers. We did 27 depositions in maybe 35 days. I deposed the CEO of Chevron. I mean, it was. And by the way, you know, I used to be a litigator at the public defender in DC, so like I know my way around litigation in the court, but I'm not a highly skilled litigator. I'm just not. You know, I've spent a lot of time in Ecuador, and I couldn't get a lawyer, so we did all this stuff. And bottom line is, 2 weeks before the trial, a lawyer named Rick Friedman, who is principal of a law firm in Seattle called Friedman Rubin. By the way, if any of you guys want to do plaintiff's law, it's a great small law firm. And he agreed to come in and represent me pro bono in this enormously complex case that he had basically 2 weeks to learn. But we all knew when that happened that we were not going to win this trial. Like, the whole point of the representation was to create a record that we could take up on appeal. So the case went on for 7 weeks. Ultimately, Chevron paid a Ecuadorian man $2 million plus to come in, and he claimed he was in a meeting with me where I approved a so-called bribe of a trial judge in Ecuador, which did not happen, but he testified to this. There was no jury, and the judge credited his testimony, and at the end of the day found that I had committed fraud and was guilty of racketeering in the Ecuador case. But because they didn't want a jury, they had dropped all the money damages claims against me. And there was no money damage at the end. So remember the $60 billion, like, that had disappeared. So all they really had was a decision by a trial judge, which is more like, in my opinion, like an advisory opinion, that what had happened in Ecuador was fraud. And what Chevron wanted to do with this opinion, besides wanting to use it to completely screw up my life and my career, was they wanted to take it into foreign courts where we were going to go to enforce the judgment against their assets and claim that a U.S. judge had found the whole case was a fraud, therefore you cannot enforce the Ecuador judgment. And simultaneous to this, we had filed an enforcement lawsuit in Canada. Chevron has significant assets in Canada, which is a big petro state. And we had made enormous progress in Canada. We got a Supreme Court decision in Canada in 2015 giving the Ecuadorians the right to enforce their judgment in Canadian courts. It's actually a very significant human rights decision, in my opinion. And as we started to gain momentum in other courts, Chevron went back to Judge Kaplan, who at this point had found me liable for racketeering, and asked him to hold me in contempt of court because I wouldn't turn my computer over to Chevron. Okay? And there has never been, by the way, an order in a civil case context where one side's counsel has been ordered to turn their computer over to the other side in the middle of litigation. And I told Judge Kaplan, I said, I was very honest, I said, I can't do that. I think what he was trying to do was put me in a position where I'd either have to choose between complying with a court order or completely screwing over my clients in Ecuador, violating my ethical duties to my clients. So I put it out there very clearly. And by the way, I'd go into court alone and they'd have like 15 lawyers. It'd be like me and 15 lawyers, Chevron lawyers from Gibson Dunn. And I asked him to hold me in civil contempt of court. Because I don't know if you know this, but in a civil litigation, the only way you can appeal a discovery order in the middle of a litigation is to be held in civil contempt. And then you can take your appeal up. Otherwise, you can't appeal. You're obligated to comply and then deal with it on appeal if you lose the underlying case. So, I knew what they were up to. This was just another attempt for them to try to force me off the case. And ultimately, they, I appealed Judge Kaplan's order, as I said I would. He held me in civil contempt. And a few weeks after I did that, he charged me with criminal contempt based on the same conduct. So while my appeal of his order was pending before the Second Circuit, he charged me with criminal contempt of court for appealing his order. When you think about it, that never happened before. So I'm like, holy, this is really interesting. So I didn't have a lawyer. I was shocked that this had happened. I was actually in Canada at the time working on the enforcement of the case. And I came into court and he had appointed a private lawyer to prosecute me. I found out that he had taken his charges to the U.S. attorney in the Southern District who refused to prosecute me. So he appointed a private lawyer from a law firm called Seward and Kissel, which is based here in Manhattan. And he didn't disclose at the time that Seward and Kissel had Chevron as a client and a bunch of big oil and gas companies. And he also had assigned the case to a friend of his, Loretta Preska, who's a leader of the Federalist Society, and Chevron is a major donor of the Federalist Society, as is Gibson, Dunn, and Crutcher. And it was like all like this little kind of thing going on. I'm like, this isn't right. This doesn't smell right. And immediately the so-called prosecutor, because she was really a Chevron lawyer in my view, asked for me to be locked up as a risk of flight. Locked up as a risk of flight. And by the way, the contempt charge was a misdemeanor. I know of no other case in our history where a lawyer charged with contempt has been detained prior to trial. I've never seen it, it's never happened, other than to me. She also asked for an $800,000 bond. I mean, I know some of you probably work in clinics doing criminal defense cases. I challenge anyone to find a single other misdemeanor case in New York or anywhere in this country where the bond for someone with no criminal record was more than zero, frankly. Okay, mine was higher than 3 out of the 4 cops who killed George Floyd. On top of the detention, which under the law was considered a pretrial release with conditions. Like it wasn't, to the court it wasn't detention, it was a pretrial release. So I then went to my apartment, and because of COVID and various other reasons, this went on for almost 3 years. Before I even had a trial, okay, before I had a trial, I was in my apartment with an ankle bracelet for 2 years and 2 months on a charge that carried a maximum sentence of 6 months in prison. So I had already served 4 times the maximum sentence before I could even get to trial. But the crazy part is because of the way US law works, and I don't actually think this is aligned with international human rights law, but the way US law works, they're like, no, you weren't in detention for 2 years and 2 months, you were free. You were free. So I went to trial. Judge Prescott denied me a jury. I mean, it was all preordained, the outcome, just like the RICO trial. I've never gotten a jury on any of these cases. And she convicted me, sentenced me to 6 months in prison, the maximum term, even though at that time I had already been detained for by that time, 2 years and 5 or 6 months. She tried to force me into prison the very day she sentenced me, which is very unusual. I mean, and again, in a misdemeanor case, people who have appeals don't, first of all, you never get a prison sentence, period. Most you'll get probation or some sort of penalty that doesn't involve prison. And she tried to force me in that very day. We sort of stymied her, and she basically said, if you file your appeal for what's called bond pending appeal, like I had to file for another bond to stay out pending my underlying appeal of her conviction, I'll let you go home, but this has to be decided within, on an expedited basis, and you have to file your brief in a week. That's what she said to us. So we did that. I went home, and it went up to the Second Circuit, and very quickly they denied my motion for bond pending appeal, meaning I would have to serve my prison sentence before the appeal of this incredible case could be heard. So once they ruled, she had told me I had to report to custody within 24 hours. 24 hours. It's all just psychological warfare, right? Because usually, especially white-collar defendants like me, you're told by the Bureau of Prisons your date you should report to X facility, and you're allowed to go there voluntarily. So she was trying to kind of interfere in that process, mess with the head of me and my family. So once they ruled, I had 24 hours to get myself into custody, and I basically had a car, and we drove to the Danbury prison in Connecticut. And remember, the whole basis for my detention all this time was that I was a risk of flight. She was saying stuff in court like, he knows people in Ecuador, his clients love him. And if he gets to Ecuador, I didn't have a passport, for me to get to Ecuador, it would have required me to go overland over 8 borders with no passport. And I would never do it anyway, but the stuff they were coming up with to sort of keep me detained was crazy. So in any event, I reported to prison. I've never been so happy, honestly, to walk into prison because I was so scared that they were going to do something to me. Honestly, I had avoided prison as much as I could because I kept thinking about Jeffrey Epstein, to be frank, and I kept thinking, like the forces trying to hurt me are so powerful. And prison is so lawless. I just was like, you can't go to prison. Like I wasn't inherently scared of prison if I could just be treated normally, like a normal prisoner. Although I didn't want to go to prison, obviously. So there was a lot of psychological stress, but bottom line is, to make a long story short, I got to prison, and the staff treated me very professionally, and they wanted me the F out of there as soon as possible, because I was getting, 50 letters a day. Amnesty International put out an urgent action bulletin about me, which helped me so much. By the way, no matter what you think of Amnesty, support them. Like, this stuff really does matter. And because I was getting so much attention, and I had congressmen that I had been working with who were like calling the warden trying to visit me, they don't like scrutiny in prison, and they wanted me home. And under COVID, there was a law that allowed anyone 60 or over. This is crazy. So remember, I kept delaying. Everything got delayed. So by the time I got to prison, I just turned 60. My birthday was in September, and I went to prison in October. And I didn't even know there was such a law. But Congress had passed a law that if you're 60 or over, you could go home and serve the rest of your sentence at home after serving 25% in prison. So they got me out on the very first morning when I hit 25%, which was 45 days, which was December 9th of 2021. And I came home after 45 days, and then I had to put the ankle bracelet back on and keep going another, for the rest of my term, which ended in April 25th. So where are we? Right now, I'm good. I really am. I'm really proud of getting through this in the way that we have. And I say we, I mean me, my family, my friends, our team, people of Ecuador. Unfortunately, the people really hurting are still hurting, like they haven't collected any of the judgment. However, there's no statute of limitations on international judgment enforcement. This case is still completely viable. They are scared of this case. They refuse to give me my passport back. They do not want me leaving this country. And talking to law firms in other countries where Chevron has assets. I'm spending a lot of time, I'm writing a book right now on the whole experience. I have a book deal. I'm developing other sort of projects. I'm doing a lot of speaking, and I'm really trying to get my life back. But I will say they did disbar me based on Judge Kaplan's RICO decision without a hearing. I could never get a hearing to challenge this decision in a civil case without a jury. I was disbarred based on a decision by one judge in a civil case without a jury, and the Bar Grievance Committee wouldn't give me a fact hearing to challenge Judge Kaplan's findings that I bribed the judge in Ecuador, even though I had ample evidence to challenge it. So I lost my law license, I think unfairly. It doesn't mean I can't get it back. I have lost my right to travel. We're going to try to get it back, but it's going to require me to go right back to Judge Kaplan to do so, and I just don't think he's going to do it, which would embroil me in like another 2 years of litigation, very expensive litigation. So I'm not sure that's going to happen, at least not in the near term. And then I did ultimately take the conviction by Judge Prescott, the misdemeanor contempt conviction, all the way to the US Supreme Court. Some of you might have read what happened, but the court denied cert. Again, this is the nation's first private corporate prosecution. And we did get a really well-written dissent out of Justices Gorsuch and Kavanaugh. I mean, it's unbelievable when I think about this. What had happened, by the way, is I got a lot of support from the Federalist Society circles, ultimately, on the theory of the unitary power of the executive, which is like a big FedSoc kind of thing. My case became embroiled in this sort of philosophical conflict between those who believe in greater executive power and those who believe in greater judicial power. Because my prosecution, after it was rejected by the US attorney, became a judicial prosecution, not an executive branch prosecution. And under separation of powers, that really is not legal under our Constitution, not to mention it's completely misaligned with international law. But Gorsuch, in his extremely well-written dissent, nailed it. And it sort of shocked me that the 3 liberal justices didn't join in, because had they, my case would have gone up and my conviction would have been reversed. So where things stand now is, private corporate prosecutions initiated by a judge can happen in the United States. I mean, they didn't reverse it. I don't think they're really that into it. I'm not so sure it will happen again just because of how this has gone down. I mean, it looks really bad, but they weren't overturned, and in theory, they could happen again. And again, I think the fossil fuel industry, the Chevrons of the world, they like having the leverage of those of us who want to do the climate fight, having to sort of consider the possibility that this kind of thing can happen. Like when you make your career decisions, or when you decide to initiate a case or work on this, that, and the other thing, if you have to sort of think that that could happen, you're going to sort of have to factor that in, right? So there's really a much larger battle going on in our country that I'm sure you're very aware of. My case, I think, is a symbol in many respects of these larger forces at play in our society, this increasing corporatization of our judiciary, influence of the Federalist Society. You see police forces being privately funded by fossil fuel and pipeline companies to arrest protesters at pipelines like, Line 3 in Minnesota and Standing Rock. Like, we're seeing a lot of features that I think are very, very, very disturbing. And, when I was in law school in the late 80s and early 90s, and my law school classmate Audrey Baker is here. Hey, raise your hand. She heads the whole international programs at Columbia. So if you want to go abroad, she'll help you. Anyway, there's a lot of things happening, obviously, that are problematic, and I think that we need to see them for what they are, and as we embark into the world and you sort of take jobs and figure out what you want to do, you need to be cognizant of these issues and also cognizant of the legal things that I think need to happen to better protect freedom, in our society, better protect free speech, better protect your right as a lawyer, as an advocate under the Constitution to do your work without fear of reprisal, political reprisal, by our court system. Okay? So I'll stop there and open it up for questions. Thank you. Thank you so much for that. Do you have a way you want to do questions? Okay, yeah, maybe raise hands and, yeah, they're in the back.
Can you use the thing on your desk to mic?
I wonder, you're not being able to travel, what that makes you think about the chance for information sharing and strategizing and maybe alliances in multiple places?
Thank you. Look, I think to build kind of alliances to deal with these human rights questions that cross borders, you have to be able to travel. I mean, the reason we built the force that we did is because I went to Ecuador constantly. The model that we created, I think, is special. It might be unique. The model between indigenous leaders and lawyers in the North and funders, by the way, we had a whole economic component where we got donations as well as investment funding to sustain the case all these years. Not being able to travel is crippling. It's absolutely crippling. I mean, Judge Kaplan ruled the Ecuador case cannot be enforced in U.S. courts, but Chevron's vulnerability is they operate in dozens and dozens of countries. So if the main lawyers, or lawyer, meaning me, cannot meet with other law firms in other countries, it's just not going to happen. I mean, you can't deal with a case of this level of complexity on Zoom. It's not going to happen. To get lawyers to take this on requires a huge amount of vetting and work. I mean, months of vetting. So, part of what they've tried to do is create atmospherics around the whole case through attacking me that make it even more difficult to raise capital to fund it. Capital becomes more expensive. And the lawyers you meet with, we had been working with lawyers in Canada, like, you sort of walk in the room and like the burden is on you to show that what Judge Kaplan decided is wrong. That you really need to believe the fact that this case has been affirmed by Ecuador's highest court unanimously. The enforcement part's been affirmed by Canada's highest court unanimously. You need to believe that over Judge Kaplan. And one thing I learned, this is crazy. There's such a, I think, disproportionate amount of deference giving U.S. courts in other countries. Like we would go to these and be like, well, the people were just innately believing this one federal child judge who was, in my opinion, really biased over multiple judges on multiple courts in Ecuador who really looked at the evidence. Judge Kaplan never looked at the evidence in Ecuador. He just went on this paid false witness testimony from Chevron to find that I had committed fraud. So, structurally, the way the legal system functions in the world really favors these corporations and disfavors human rights victims. Because they just assume a lot of the law firms and a lot of the judges in Canada, I've noticed, sort of are like judges here. They're just highly skeptical of a judgment out of a less developed nation as compared to a trial court judgment, from the US. And if you really take a step back, it's mind-blowing. Judge Kaplan, if you really think about what he did, is he basically, from his Manhattan trial court, tried to overturn Ecuador's Supreme Court. That's what he essentially was doing. I'm going to rule on a high court decision from a sovereign nation, a U.S. ally, and I'm going to overrule it. I'm going to rule on their ruling, and their ruling's wrong, and therefore that ruling shouldn't have any validity in any court in the world. That's what he tried to do. And it's had a big effect, and how it continues to play out remains to be seen, but it takes a lot of work to sort of make up for that kind of thing.
Thank you very much for your sacrifices, your struggle. I wanted to ask you about the International Arbitration Court finding and how that fits into it, and also the Canadian enforcement process and any other enforcement processes. Thank you.
Thank you for the question. So the question concerns an international arbitration ruling against the government of Ecuador, claiming that the case in Ecuador was a fraud and therefore Chevron doesn't have to pay the people of Ecuador. So I don't know how many of y'all study international arbitration, investor arbitration, but the United States has literally dozens and dozens of bilateral investor treaties with countries all over the world that protect U.S. investment in those countries. And the way it works is if you are a company investing, say, in Ecuador, in this case Chevron, and you get angry at something that happens to you because of a governmental policy or a legal decision, the treaty gives you the right to sue the government, not in Ecuador, but in this private secret arbitration process where private arbitrators who are paid huge sums of money, commercial hourly rates, decide who's right and who's wrong under some sort of vague notion of international law in cases that are not public, and they're really hard to get the briefs and they're hard to participate in if you're like the affected party like my client. So Chevron used the U.S.-Ecuador treaty to sue the government of Ecuador, trying to shift all of their liability that we had won, it's now about $10 billion, to the taxpayers of Ecuador. They're really, if you think a little bit deeply about it, they were using the international arbitration process to try to get a judgment against the government of Ecuador for the full amount of their liability owed to the communities that they harmed. That is, government is taxpayer funded. They were looking for a taxpayer funded bailout from their victims. So this process, this case began in 2009 before our case had even finished. And it's still going on. This is the mother of all arbitration cases. It has cost hundreds of millions of dollars. I happen to know for a fact it's cost the government of Ecuador, which does not have a lot of money, which has huge needs on health care all sorts of social service needs for its population. It's cost them $150 million in legal fees just to deal with Chevron's hiring of King and Spalding, by the way, is the firm representing them on the arbitration. And King and Spalding has probably billed literally $1 billion on this case. So ultimately, the question, and they won the case, although it's on appeal right now. The question with that case is, what impact would it have on the real case? And again, Chevron is just like they tried to do with me, and the decision from Judge Kaplan, they take the arbitration decision and they're going to try to use it in international courts to say this case is illegit, you can't enforce the judgment because Donziger was found guilty of fraud, and now this arbitration panel in a case that I was not even a party to, nor were my clients, found that the whole judgment, they basically bought into what the same thing Kaplan did, Chevron's false narrative. And it's a battle, and I don't think the world has ever seen a situation where a private investor arbitration decision collides with a legitimate public court decision in tort. That's never happened. I do not believe, at least I would like to believe, that the arbitration decision will have any impact in any way, shape, or form on the enforceability of the judgment, because it shouldn't. I mean, the Ecuadorians were not a party to that arbitration. But of course, Chevron will use it to consume resources, time, and use it to try to influence the court. So there is this kind of thing dangling out there in the world, this arbitration decision that will play some role in the ultimate enforceability of the judgment. Hope that answers your question. Yes.
I'm wondering if you could talk more about why you initially wanted to bring the case in U.S. court rather than Ecuadorian court. Was it legal theories available, likelihood of success, enforceability, remedies? What was it?
So, why did we bring the case in U.S. courts initially? I mean, it was fundamentally because no one on our team nor our client base trusted Ecuador's courts to deal with this in a fair way, because they had essentially given Texaco impunity for over 25 years. So it was more like there's no way, they felt like they could not get a fair trial in their own country. So, and then, at the time, we're like, we could get a trial in the U.S., we could get a jury trial. By the way, human rights law in the 90s when this started looked a lot different than it does today. The Supreme Court has taken, in a series of decisions, has really limited, like the Alien Tort Claims Act and some other mechanisms you can use to litigate human rights cases. So at the time, it sort of made sense to us to come here. Ultimately, the roles reversed, and they were like, oh, Ecuador, at that time they were like, Ecuador's courts are great, they're transparent, they had affidavits from experts, these are the best courts, blah, blah, blah. And we're like, no, we want to be in the US, and ultimately we were forced back down to Ecuador, and once we started to litigate the case, put in evidence, they then switched their tune and started to accuse Ecuador, the very courts they had earlier praised as being great and fair, they started to say they were corrupt. So the Gibson-Dunn and the Chevron strategy was always just to, adopt any position they could in the short term that would best help their position. There was no consistency other than, in my opinion, the lack of ethics to how they litigated.
Thank you for coming. Why do you think that the Canadian legal system was more fair, given that you did say it was still a petro state? What was different about that system?
So, Canada, I've learned a lot about Canada. I've been there a bunch of times dealing with this. I don't know if do we have any Canadians in the audience by chance? Yeah. Are you guys LLM students or? No, okay. Look, Canada, Canada and the U.S. have similar histories with the Indigenous and First Nations people, similar horrific histories, but Canada, I think, pays much more lip service toward doing the right thing by human rights and by First Nations people than the United States, which doesn't even seem to even try, Canada also has more respect for international human rights law. I mean, most judges in our federal judiciary, not only don't respect it, they go out of their way to just laugh about it, So I think Canada is a more fair rule of law country than the United States. The appointment of judges is much less politicized than it is here. Having said that, though, most of the judges in Canada come out of the corporate law world, just like here. And it's still structured in a way that it's sort of more difficult for people like indigenous peoples in the Amazon than it would be, say, for a commercial litigant. I mean, I'm not saying Canada is easy, but I am saying that given sort of, you know, their court system, their judiciary being, I think, a little more fair than ours, it's a better place for the people of Ecuador to litigate. The hostility that we have gotten from Judge Kaplan is just unbelievable. Like, I just can't imagine that happening in Canada. I can't imagine a judge going after a lawyer and locking him up in Canada. I mean, it's just people, my Canadian lawyer friends are just stunned. So for those reasons, Canada's a good option for the communities of Ecuador as they think about where to go. And also, you know, Chevron has a lot of assets here. Like, you can't really be an oil major and not operate in Canada. It's just too much going on up there. So, yes.
I just wanted to say thank you for all that you've done to protect our indigenous communities of Ecuador, and that your work has had a very long impact on different regions in Ecuador. And I was wondering if you could please speak to more of the current environmental state that Ecuador is in, and if you could also speak to some of the long-term implications and harm that were incited by Chevron and Gibson Dunn, and how the work that you've done has played into the current state of where Ecuador is at in terms of the environmental factors.
Thank you for the compliment and the question. You know, the thing about Ecuador is, I mean, this is crazy. You know, I've been there so many times that I almost feel like it's a second home to me. I mean, I have friends there, and I know the newspapers, and I know people and leaders, and, you know, the indigenous leaders. And it's been, even though, you know, I've had to deal with everything I've had to deal with, I just want to say this. And by the way, they took all my money. One of the end results of the RICO case is after they denied me a jury trial, so they couldn't get a money judgment, they got Judge Kaplan to impose literally millions of dollars of court costs on me to repay them for their legal fees they used to essentially persecute me. And they went into my bank accounts and just wiped me out. So I'm heavily reliant on my legal defense fund to pay my legal costs and survive. I mention that because, I mean, first of all, you should know that. Like, there's a lot of tools of repression that these corporations have at their disposal if they can convince judges to play along to disable advocacy. But I was really determined when that happened not to be disabled, so I just started this defense one, which, by the way, has been pretty successful. And if you want to check it out, go to freedonziger.com. I'm not asking you to give. If you want to give, please give $1. I don't care, but there's a donate button. But more importantly, you can get a feel for what people in my position have to do when they get hit like this. Like, there's ways you can deal with it. As regards Ecuador, I love Ecuador. I wish I could go back there. You know, when I got my ankle bracelet off on April 25th of last year, I would have been on a plane April 26th had I had a passport. You know, we developed, I and our legal team with the client base just developed really close relations. And you know, one thing I learned culturally, you know, I don't know how you guys feel about this, but I went to Harvard Law School. And they sort of teach you, like, you can get out and do anything. You know, you can run a business, you can rule the world, you can change policy. And when I first went down to Ecuador, I had like that kind of attitude, like, I'm going to help these people. And over time, I became the one helped. I mean, it was crazy. I mean, this really did happen over time. Like, I learned so much more from them than I think they ever learned from me. You know, not just about law, but about life, about the natural world, about the environment, about justice. I'm sorry, I'm getting emotional. It's just, you know, unbelievable to sort of go through this and end up, I mean, I basically have no money right now, other than my defense fund. But I don't feel impoverished. I actually feel quite wealthy for having had the experience. So, I mean, Ecuador, as you know, is complicated as hell. I mean, governments, some governments were like respectful of the people doing the case. The current government is like completely pro-Chevron. They're doing all they can to help Chevron. You know, dealing with that was a constant headache and took energy and resources. And one thing I'll say about these cases, if you get into this space as lawyers, is you cannot count on how the law says it works. Like, you can't file a case and just assume you're going to get a trial quickly, or assume you're going to get even a fair trial. You can't assume a judge will be fair. There's all sorts of dynamics at play that sort of diminish the promise of the law. Just telling you. I mean, look, you folks are not naive, you know this, but I'm just telling you, it's deep. It runs deep. And I think my advice, I'm digressing slightly, but my advice as you take on these tasks to really help people and to help save our planet, is the key is at the beginning, you need to sort of diagnose the landscape. You need to have the tools to diagnose the landscape, the correlation of forces, the power structure, the dynamics right up front, so you can figure out strategies. You know, and one thing we realized in Ecuador, getting back to Ecuador, is there was so much racism in Ecuador against indigenous peoples, against our clients, that we didn't feel like we could get a fair trial in Ecuador until we sort of changed that dynamic. You know, when I first got to Ecuador, you talk to the elites in Quito or Guayaquil, and they'd be like, oh, that case against Texaco, you know, the Amazonicos, and, you know, it was just very kind of racist. And we set about, through the media and other mechanisms, to change it from, you know, the indigenous peoples against Texaco to a dynamic where it was like the country of Ecuador against a U.S. oil company. We need to change the framing of the whole case to get the country behind the case. You know, so judges could do their jobs. Like, judges operate in political environments, and you have to be aware of the environment in which you're operating. When you are representing people who are marginalized and do not have a lot of power, you have to think about ways to create power and leverage so you can get the courts to do their jobs. I'm not saying do this to get favoritism. Just do it so the other side doesn't get the favoritism. Do it so you can have a fair shot in a fair trial. So I think developing techniques and tools to sort of make these assessments, this is true for any political campaign, legal case or whatever, is really, really critical. Like, you don't want to get into a situation where you're not assessing properly, you don't come up with the right strategy, and you're left personally vulnerable. I mean, I was personally vulnerable. I'm not blaming myself. I couldn't anticipate this shit. You know, when I think of like worst case scenarios, I couldn't anticipate a private corporate prosecution. That never happened before. I couldn't anticipate a RICO case without a jury. Never happened before. I couldn't anticipate disbarment without a hearing. Never happened before. So I don't want to beat myself up about it, but I think we had threatened them so much that they just started to change the rules. So now you guys, when you sort of go out into the world, have to understand the landscape as it exists today, not necessarily as it exists in law books, you know, and how they teach you. Because I can promise you, and I don't mean any disrespect to professors, faculty, I know there's great faculty here and this is a great law school, but I promise you your education is incomplete. Okay, you are not being taught some of the ugly aspects of our system that you're going to face if you do human rights work at a successful level. I think there's a question back there. Oh, 2 more minutes, okay. Sorry for being so long-winded. Go ahead.
Thanks. Yeah, so I think on the whole, there's been a lot of efforts to hold companies accountable for both their environmental impacts and their human rights impacts. As you mentioned, the ATS is kind of dead, the Nestle case. Even for Ecuador and Chevron, there was a case, a complaint filed at the International Criminal Court, and that was dismissed for lack of jurisdiction. And even the Dutch Beloew Defensie case, I mean, Shell hasn't paid